actually a much more aggressive approach to close what Obama terms as trust loopholes. First of all, let me back up by giving you a little bit of background for those who are not familiar with the concept of GRATs. A GRAT is simply a grantor retained annuity trust, meaning that the person who funds the trust is transferring assets in exchange for a promise to receive an annuity for a period of years. Traditionally, these GRATs have been structured to be such that we refer to them as zeroed out or almost zeroed out, meaning that if I, for example, transfer an asset worth $5 million to a GRAT and the trust promises to pay me the equivalent present value of $5 million, then in fact I have not made any gift at all, and I can, by doing so for the term of years, if that asset appreciates to, let's say it doubles in value to $10 million, the trust has paid me back the $5 million that it promised to pay me back, and what remains in the trust, free of any transfer tax, is $5 million for the next generation, for the beneficiaries of the trust. And we have traditionally done that, and there have been no gift tax consequences because if the gift is zero, we're not using up any of our exemption. The term we've often used is the minimal term of 2 years, because if the grantor dies during the term, then all bets are off and there will be inclusion in the grantor's estate. So we would typically, if the stock had not gone up in value, if the asset hasn't appreciated during that 2-year term, then we would simply re-grat the assets as they come out into a new grat for 2 years, and we would do this on. And some clients would experience losses during that period, but no harm, no foul, because they just get the assets all back. They haven't wasted any gift tax exemption, and they can start all over again. Well, Obama's administration sees that as a loophole. Of course, there is the ability of getting significant appreciation out to the next generation, and we've had clients that have been very successful with their grats to the extent of millions and tens of millions and hundreds of millions of dollars that has escaped estate and gift taxes over the years. So what the legislation proposes is that the minimum term, first of all, would be 10 years. That would be somewhat unattractive because if a client dies during that 10-year term, then again, we failed the objective. In addition, to stop the game that was going on by some planners, they would have a maximum term, they would have a 99-year term. And by having a 99-year term with a reduced annuity in the final year percentage, you could game the system in such a way that if the annuitant died during the term, the amount includable in his estate would be a very small percentage. And so, again, the legislation provides that the maximum term can be only the annuitant's life expectancy, according to the IRS charts, plus 10 years. The more troublesome part, which I think takes grats completely out of the planning horizon, is that the remainder interest, that is the amount that one must settle for a gift value subject to gift tax, must have a minimum value equal to the greater of 25% of the value of the assets contributed, or $500,000. So, for example, if I transfer an asset worth $2 million, 25% would be $500,000. That is the equal to the greater of. If I transfer an asset of $10 million, it must have a remainder interest of $2.5 million, which means that I've now used up $2.5 million of my exemption. The problem with that is if the asset goes down in value, unlike a zeroed-out gift, if the asset goes down in value and I've used up $2.5 million of my exemption and I get the $10 million asset back in my estate, which is now, let's say, worth $7 million, so no wealth was transferred to the next generation, I've still used up my $2.5 million exemption. So unlike the current law where there's no harm, no foul if the asset value goes down because I've zeroed it out, that would not be possible, and that means that grats are pretty much dead in the water if this does come to pass. Let's talk a little bit about sales to grantor trust. Sales to grantor trusts are also used for a similar purpose as grats are. In some ways, they're more attractive than grats because a grat can't really be used, at least not certainly, because there are some unknown factors to benefit generations beyond one generation, that is a skip person. But a sale to a grantor trust can certainly be used to get the benefit for generation skipping purposes and could last in perpetuity. And so if I, again, to give you an example, if I have an asset that's worth $10 million today and I were to sell it to a trust, first of all, the trust might be a trust that is seeded with some capital, some investments in there already. Typically, we used a 10-to-1 ratio. So assuming the trust has been funded with $1 million gift prior thereto, and now we sell a $10 million asset to that trust in exchange for a promissory note. That note can be for a fixed rate equal to the very low, current low rates that are prescribed by the Internal Revenue Service each month. The current rate is for a short-term note, which is a note for less than 3 years, is 40 basis points. That's 0.40%. And the note would be payable, let's say, in 3 years, or it could be payable in 30 years, in which case it would get the long-term AFR rate, which is approximately 2.5% these days for a note that's over 9 years in length. And so during that period, if the asset appreciates in value beyond the AFR rate that has to be paid back to the grantor on the note, and let's say it's a balloon note that's payable at the maturity date, then all of that excess future appreciation goes out to the next generations. And so the Obama administration proposes to basically include in the grantor's estate when he or she dies the portion that was not previously subject to gift tax. So in this case, in my example, if the $10 million asset appreciates to $30 million, the grantor is getting $10 million back, so there's $20 million left in the trust that was not subject to gift tax. That $20 million will be subject to estate tax as part of the grantor's gross estate. And if the grantor trust no longer has no longer is a grantor trust, and what by that I mean a grantor trust is a unique type of trust set forth under the Internal Revenue Code sections 671 through 679, which provides that at all times the grantor will pay the income taxes on the trust's income and therefore reduce the grantor's estate directly and enhance the value of the assets in the trust because the trust isn't burdened by the payment of income tax each year. So oftentimes what we will do if a grantor no longer wishes to pay the income tax, and particularly maybe after the note has been paid off, we might turn the spigot off so that the grantor isn't burdened by the income tax. Under this legislation, however, that will subject this excess appreciation to a gift tax. And these taxes, gift taxes or estate taxes, will all be payable from the trust, and that means, again, depleting the trust's assets, which today is not otherwise the case. This proposal would not be applicable to trusts that are already includable in the grantor's gross estate by virtue of the statutory provisions under the code. For example, GRITs and GRATs and personal residence trusts all provide that if the grantor dies during the term, those assets will be includable in the grantor's estate, so there's no need to do anything beyond that. And in a correction of a portion of the legislation proposals of 2014, where there was a lot of talk about the fact that ILITs, insurance trusts, would be caught under these grantor trust proposals. The administration has accepted that would not be something that would merely hurt the 1% high net worth individuals, but it might go beyond that and hurt middle class people. And so they've now excluded the ILITs from being includable in the estate tax of the insured decedent. With that, let me turn it over to my partner, Dan, to talk to us about some of the other salient estate and gift tax provisions. Dan?
Thank you, Gideon.
Sorry about this delay here. Hopefully you can hear Dan now. Not yet.
Thank you. Sorry for the technical difficulty there. This is Daniel Rubin. I'm going to continue our presentation by talking about the generation skipping transfer tax. So as I would imagine most of us are aware, the generation skipping transfer tax is a third transfer tax, a transfer tax in addition to the estate and gift tax. And the generation skipping transfer tax is, of course, imposed when a person makes a transfer to a person or to a trust. But let's think about it as a transfer to a person who is more than one generation removed from the transferor. So a transfer to a grandchild would be a transfer that would typically be subject to the generation skipping transfer tax. And the generation skipping transfer tax, like the estate tax and like the gift tax, is imposed at a rate of 40%. In fact, unlike the estate and gift tax where the rates go up to 40%, the generation skipping transfer tax is imposed under law at the maximum federal estate tax rate. So it's imposed on $1 at a rate of 40%. Now, just like the estate and generation skipping the estate and gift taxes, there is an exemption against the federal generation skipping transfer tax, and that exemption is $5.43 million in the year 2015, just as it is for the estate and gift tax. But it's a separate exemption. It's called the generation skipping transfer tax exemption. So if I were to take up to $5.43 million of property, assuming no prior use of my generation skipping transfer tax exemption, and I were to transfer that to my grandchild, it would be covered by my federal generation skipping transfer tax exemption. That gift by me to my grandchild has the effect of skipping a generation, meaning it's not going to be subject to tax when my child dies because I didn't give it to my child, and it's not subject to an estate tax at my child's death before it gets to my grandchild. Or if I gift it to my child and then my child turns around and gifts it to my grandchild, again, there's no second level of tax. So the utilization of a generation skipping transfer tax exemption is valuable. It's even more valuable if I utilize my exemption by making my transfer not outright to my grandchild, but rather making it to a trust. So imagine I make that transfer into a trust where my child and my grandchild are both beneficiaries. And to the extent that my child doesn't need the money, it can then be retained in trust and benefit my grandchild. And since trusts don't necessarily have to die, people were utilizing the generation skipping transfer tax exemptions by placing property in trust and skipping multiple generations. Now, when the generation skipping transfer tax was first enacted in 1976 and then reenacted in 1986, the law was very different in two significant ways. The first significant way in which the law was different was that the exemption was not, of course, $5.43 million. It was a mere $1 million. And the second way in which the law was different was that most states had a rule against perpetuities. I think there are 3 states, according to the Green Book, which has done the research here, that did not have a rule against perpetuities back when the generation skipping transfer tax was first enacted. Meaning that under the law, under state law relating to trusts, you could only do so much with your exemption because the trust would necessarily terminate within a certain period of time defined by the rule against perpetuities, which you might think of as 90 to 100 years, or in some states as 21 years after the death of the last of a group of lives then in being. Now, these two things have since changed significantly. It's not a $1 million exemption today. It's $5.43 million, or 10.86 if you're making a transfer with your spouse. And in addition, in over half the states today, there is no rule against perpetuity. So you look at a state like Florida, where trusts can last for 360 years, or states like Wyoming or Nevada, where trusts can last 1,000 years, or states like Delaware or New Jersey, where states can trusts can last perpetually. And you've got a real ability to game the system, or as the government might see it, abuse the system. And that's why the Green Book and President Obama has proposed limiting your ability to stretch out your GST exemption through the use of a trust to a trust that lasts only for 90 years. Or if the trust lasts for more than 90 years, then on the anniversary date, 90 years in the future, the inclusion ratio of that trust, meaning the amount of that trust that would be subject to generation skipping transfer tax, is increased to 1, meaning that it would be entirely includable for generation skipping transfer tax purposes. Moving on to the next slide, you'll see a type of trust that's often called a HEAT, H-E-E-T, stands for Health and Education Exclusion Trust. Now, to understand the HEAT, you have to understand that Section 2503E of the Internal Revenue Code excludes from the definition of a taxable gift gifts that are made directly to the provider for the purposes of either medical care or education, meaning the payment of tuition. So a gift that's made to Harvard University, say, for the purpose of paying a student's tuition is not a taxable gift, no matter what the amount might be. And my understanding is that it's gotten pretty expensive. Section 2611B1 of the Internal Revenue Code excludes from generation skipping transfer tax, what we just discussed, transfers that are made under 2503E and therefore don't generate a gift tax because they were transfers directly to the provider for medical care or tuition. The interrelationship between these two provisions explains the HEAT, the Health and Education Exclusion Trust. Let me give you an example. If I were a grandparent and I wanted to pay my grandchild's tuition to go to Harvard University, I could make that payment directly to Harvard University, and I would incur no gift tax, and I would incur no generation skipping transfer tax, and that would be the case no matter what the value of that payment might be, whether it's $14,000 or $44,000 or $104,000. It would make no difference. There'd be neither a gift nor a generation skipping transfer tax in connection with that transfer. Well, what if I was truly wealthy and I didn't want to simply provide for my grandchildren, whom I know, but also for my great-grandchildren, who I might never meet, and my great-great-grandchildren, who I almost certainly will never meet, and so on down the generations? Well, smart estate planning lawyers developed this concept of a health and education exclusion trust. Basically, it involves the establishment of a dynastic sort of trust, which is for the benefit of future generations, current and future generations of descendants, and also one or more charities. Now, the reason why the inclusion of a charity is important is because if the only beneficiaries of this trust were grandchildren or more remote descendants of mine, then my transfer of property into the trust would be a direct skip, which would incur an immediate generation skipping transfer tax. Or if the beneficiaries of this trust were my children and grandchildren, then while it would not be a direct skip, it would be a taxable termination subject to a generation skipping transfer tax when my children pass away, and the only beneficiaries remaining in the trust are my grandchildren, meaning people more than one generation removed from me. In order to keep this gift of mine into the trust from being a direct skip or a taxable termination upon the death of the last individual who's not more than one generation removed from me, I include a charitable beneficiary. And through that mechanism, my transfer of property into the trust is not a generation skipping transfer. Now, if I limit the terms of the trust such that the only distributions that can be made from the trust are to charity or to the provider of education or health care, to one or more of the beneficiaries, then neither will the distribution out of the trust ever incur generation skipping transfer tax. Now, it's thought to be required that the charity actually have a substantial interest in the trust. Some people define that as paying a portion of the income to the charity, but conceptually, one would think that a health and education trust should work, and I guess the government is concerned that it would work as well. They also consider it somewhat abusive for reasons that I couldn't personally explain. Nevertheless, a proposal under the Green Book would do away with the opportunity to effectuate a health and education exclusion trust by defining the exclusion under Section 2611B1 as applying solely to direct transfers by the donor himself or herself to the educational or healthcare provider, and excluding transfers out of a trust for that same purpose. Moving on, let's talk about the annual exclusion gift. So as we just discussed, well, not just discussed because we were discussing 2503E, but a separate section of Section 2503, so that's Section 2503B, provides for the annual exclusion from gift tax. Basically, that section says that a transfer that is so small an amount that the government doesn't want to worry about it, and therefore they won't tax it, and they won't consider it as a use against your lifetime gift tax exemption. Now, when I say so small, it might not be so small for me, but it's so small for people who have substantial wealth. And that number has historically been $10,000 as it's drafted into the current statute, but it's indexed to inflation. So in the year 2015, it's $14,000, and it's scheduled for further increases with inflation in increments of $1,000. We often use annual exclusion gifts when we utilize insurance trusts. So I could make annual exclusion gifts to my 3 children, $14,000 per each year, or with my wife, $28,000 per through the mechanism of gift splitting. Or I might choose to use that annual exclusion by making transfers into a life insurance trust, which holds a life insurance policy for the benefit of my children. Now, a life insurance trust is somewhat unique in this regard. The reason why we're discussing a life insurance trust here as opposed to some other type of trust is because life insurance trusts need to be fed every year, because the insurance company is not going to maintain my policy and not going to pay out a death benefit upon my death if it doesn't receive its annual premium. So every year I'm obligated to pay the premium on that life insurance, and whether I pay that insurance premium directly to the insurance company or I pay it through a gift to the trust and then have the trustees pay the premium directly, either one of those situations is deemed a gift by me because the policy is owned by the trust. Now, the exception to the general rule of 2503B that a gift of $14,000 or less will be excluded from the gift tax system is that it must be a gift of a present interest, meaning that the donee of the gift must have the right to the immediate use and enjoyment of that property. When I make a gift to a life insurance trust, even if that trust is for the benefit of my 3 sons, they don't have the right to the immediate use and enjoyment of that gift because it requires a second step of the trustee distributing the property to them, and of course the trustee is not going to do that. The trustee is going to use that premium to pay the insurance premium. The trustee is going to use those dollars to pay the insurance premium. Now, the mechanism for converting what would otherwise be a future interest, non-qualifying gift, notwithstanding the relatively small amount, into a present interest, is the use of crummy powers. Crummy doesn't mean that we've screwed something up here. Crummy means is a reference to the name of the physician who in 1968 made law in the Ninth Circuit case of Crummy versus Commissioner by notifying the beneficiaries of the right to withdraw the amount that's been gifted into the trust for a certain window of time, typically we use 30 days, and notwithstanding the fact that the beneficiaries might not actually make that withdrawal, it will qualify what would otherwise be a future interest for the present interest requirement. Another situation where annual exclusion gifts might not work is where we make our annual exclusion gift in the form of an interest in a limited partnership or limited liability company. And there I'm thinking of a case called Hackle versus Commissioner, which was a tax court case from 2002, where the tax court ruled that a gift of a limited partnership interest, notwithstanding the fact that it might be $14,000 or less, didn't qualify as a present interest gift because the beneficiaries didn't have the immediate right to use the gift. It was tied up in a limited partnership, and it would require a distribution. So there, what smart practitioners have subsequently done is they've inserted a put option so that the beneficiary of that limited partnership interest that's worth $14,000 would have a window to put that interest to the partnership or back to the donor for cash, and that should qualify what would otherwise be a future interest as a present interest. Now, so what we have here is we have an annual exclusion right, $14,000 or less per year to as many recipients as we care to make them to, and we just have a couple of hurdles to jump through. Now, the Treasury has expressed 2 separate concerns about annual exclusion gifts as they currently exist. One is a little self-serving, I think. It's that there's a complexity to the taxpayer as well as a complexity to the IRS to ensure that these fairly significant requirements to qualify what would otherwise be future interest gifts for present interest treatment be met. More substantively, I think, is what expresses their second concern, which is that there's no limit on the ability to get property out of your estate through the use of annual exclusion gifts. Yes, it's limited to $14,000 per recipient, but I could make that gift to as many recipients as I care to, so it's 14,000 times 100 people times 1,000 people. And in trusts, what the Treasury has expressed concern about is the use of what they call accommodation parties. So I establish a trust not simply for the benefit of my children and grandchildren, but also for the benefit of my next-door neighbors and their kids and my law school classmates and their families and so on and so forth in order to qualify really excessive amounts for the annual exclusion. So the proposal is to limit the annual exclusion to a mere $50,000 per donor, per the person making the gift per year. So it wouldn't be $15,000 to each of my kids. It would be $50,000 in the aggregate each year. And the only benefit to the taxpayer is that you wouldn't have to worry about whether it's a present interest or a future interest. It would simply be qualified so long as it's $50,000 or less per year.
Dan, just, people might be curious as to how much money this simplification of the crummy gifts is going to generate in revenue. The revenue scoring on this for 2017 through 2025 suggests that they will raise $3 billion, $3.5 billion in revenue by simplifying the gift tax exclusion for annual gifts. And if you were wondering what restoring the estate and gift tax to the 2009 levels that I spoke of earlier, what that's going to generate, that'll generate $189 billion. And the GRATS modification will generate $18 billion. Now, I think that's probably an underestimation because people will just stop using GRATS, and I'm not sure what will become of the appreciation that would have gone into these GRATS otherwise. So I'm not sure how they score that, but it's an interesting exercise in futility, probably.
Quite possibly. I think to your point earlier, if GRATS were no longer an option, what people might do is they'd simply utilize the sale to the defective grantor trust levy. So it really would require the enactment of both these limitations on GRATS and the limitation on the use of sales to defective grantor trusts. Ira, would you like to take the next slide where we start talking about capital gains?
Thank you, Dan, and good afternoon, everyone. Under current law, most long-term capital gains are taxed at preferential rates with 20%, plus, of course, the additional 3.8% Medicare tax being the highest federal income tax rate. Under President Obama's Green Book proposal, the highest capital gains tax rate would be increased to 24.2%. Moreover, under the Green Book proposal, an additional 3.8% Medicare tax would continue to apply, making for a combined rate of 20% compared to the current combined rate of 23.8%. In addition, under current law, capital gains is only imposed upon the sale or other disposition of an asset. When an individual gifts an appreciated asset, the donor does not recognize capital gain, and the donee takes a carryover basis in the asset. When an individual dies with an appreciated asset, no capital gains tax is assessed, and the recipient receives a stepped-up basis in the asset equal to its date of death value. Under the Green Book proposal, however, the transfer of an appreciated asset would be treated as a deemed sale, such that the donor or decedent would realize capital gain at the time of the gift or bequest equal to the excess of the fair market value of the property over the donor's basis. Thus, under this proposal, appreciated assets owned at death would be subject to both capital gains tax and estate tax, although the capital gains tax realized at death would be deductible on the decedent's estate tax return if there was such a return necessary. The proposal, however, does contain several exceptions. Most notably, transfers to a spouse or a charity would not be considered a deemed sale, but gifts or bequests to a spouse would carry the basis of the donor spouse or the decedent spouse. Secondly, transfers of tangible personal property, such as household furnishings and personal effects, would be exempt, although transfers of collectibles, such as art, antiques, stamps, and coins, would not be exempt. The Green Book also provides several additional exemptions. In particular, an exclusion of $100,000 of capital gains per person with such amount indexed for inflation would be available to each taxpayer, and this exemption would be portable to the surviving spouse if it were unused by the deceased spouse. In addition, a $250,000 exclusion would apply to all residences, and once again, this exemption would be portable to the surviving spouse. Although the Green Book recites that the exclusion would apply to all residences, we have some doubt as to whether this is what was intended, given that it is far more generous than existing law. Lastly, the exclusion under current law for capital gain or certain small business stock would apply, and payment of tax on the appreciation of certain family-owned and operated businesses would not be due until the business is sold or ceases to qualify as family-owned and operated. The proposal does offer a 15-year fixed-rate payment plan for the tax on appreciated assets transferred at death, although this payment plan would not apply, for example, to liquid assets or businesses for which a deferral election is made. Under existing law, taxpayers are able to reduce their taxable income by excluding certain types of income, claiming certain deductions, and taking itemized deductions or a standard deduction. Oftentimes, high net worth individuals have effective tax rates that are lower than their highest marginal rates because significant portions of their income are deemed capital gains and thus taxed at preferential rates. In an effort to make the tax system more progressive, the Green Book proposal seeks to impose a new minimum tax called the fair share tax on high net worth individuals. According to the proposal, the tentative fair share tax would equal 30% of AGI, less a credit for charitable contributions equal to 28% of itemized charitable contributions allowed after the overall limitation on itemized deductions. The final fair share tax would be the excess of the tentative fair share tax over the sum of the regular income tax, the AMT, and the employee portion of payroll taxes. The amount of the fair share tax payable would be phased in, starting at $1 million of AGI, and would be fully phased in at $2 million of AGI. Under current law, taxpayers participate in many different tax-favored retirement plans, including pensions, IRAs, and 401ks. Minimum distribution rules apply to these arrangements, which require distributions to begin no later than the required beginning date and a minimum amount to be distributed each year. Minimum distributions also apply to balances remaining after a plan participant or IRA owner dies, and the rules vary depending upon whether the participant or IRA owner dies before or after the required beginning date, and whether there's an individual designated as the beneficiary of the plan. Although spouses receive the most preferential treatment as beneficiaries of these tax-favored retirement plans, non-spousal beneficiaries in such accounts have traditionally been able to receive distributions over their lifetimes, which has enabled significant tax deferral for such beneficiaries. The Green Book proposal, however, seeks to eliminate the ability of a non-spousal beneficiary to take distributions over his or her lifetime, and instead seeks to require that such beneficiaries take distributions over no more than 5 years. The proposal provides exceptions for beneficiaries who are either disabled, chronically ill, less than 10 years younger, than the plan participant or have not attained the age of majority. These beneficiaries may continue to receive distributions over their lifetimes, with the exception of a minor who, under the proposal, must receive all distributions no less than 5 years after attaining majority. Although retirement accounts already have annual contribution limits of various types, the potential to contribute to multiple different types of accounts at the very same time creates the potential for very large retirement accounts. As a result, the Green Book includes a proposal that would limit ongoing contributions to retirement accounts once all the account balances in the aggregate exceed certain thresholds. Specifically, the rules would limit the aggregate of all tax-favored retirement account balances to an amount that is sufficient to purchase the maximum lifetime annuity permitted under a defined benefit plan. Given today's interest rates, this would equate to an account balance of $3.4 million for a 62-year-old, although this limitation is adjusted annually for inflation. To the extent that an individual's aggregate account balances across all of his or her retirement accounts exceeds this threshold, the otherwise applicable IRA, 401k, and other contribution limits would be reduced to zero. In other words, no new dollars could be added to any retirement accounts once the threshold is exceeded. If the account balance ever falls below the threshold due to a market decline, for example, contributions could resume. Whether any of the aforementioned proposals become law remains to be seen, but obviously enactment of any one or more of the proposals would have a dramatic effect on the tax landscape. And with that, I'm going to pass the mic over to Dan for some closing remarks.
Thank you, Ira. So this is perhaps the most important slide that we're going to see today, which is not what the proposals are. We've got an understanding of those now. But rather, what might we do? Because we are estate planning lawyers. What planning opportunities exist? Well, I think it's important to note that for all of the proposals that are highlighted on this last slide, their application is defined as being for trusts that are created or funded after the date of enactment of a new law. So obviously these are proposals at the moment. There is no law yet, and therefore we have the opportunity today, before the date of enactment, to consider funding new grads. Now, it actually happens to be the case that today, March 2015, is a very opportune time for our clients to establish grats, and the reason why is because the Section 7520 rate, which is the hurdle rate for getting property outside of your estate in connection with a zeroed-out grat, is a mere 1.8%, which is just about as low as it's ever been. And based on my imperfect understanding of the financial markets, it's only going to go up from here. We might also consider sales to defective grantor trusts. Again, we have that option today because no new law has been enacted on this, and the proposals apply only after the date of enactment of a new law. A sale to a defective grantor trust also would be a wonderful technique to implement today because of the interest rate environment that we're in. Gideon mentioned that the short-term AFR for an obligation of no more than 3 years is only 40 basis points. If we're looking at a midterm obligation, which is more than 3 years but not more than 9 years, our required interest rate is a mere 1.47% this month. And if we're looking at a long-term rate, which is an obligation in excess of 9 years, and then even then we're only looking at 2.19%, which is why so many of our clients are looking to refinance their mortgages at the moment because rates are so very low. Also a good time to swap low basis assets out of our grantor trusts. And query here whether you or your clients even consider this. When was the last time we spoke to our clients about their successful grats or their defective grantor trusts to ask what's in that trust? And is that asset a low basis asset? And should we be swapping in high basis assets or cash in order to get that low basis asset out of the trust back into the client's estate, where it's going to get a stepped up basis when the client dies, assuming no change in the law in that regard. And finally, what do we do with our insurance trusts? Well, for many of our clients who have numerous beneficiaries, their opportunity in the past has been to take $14,000 per year, multiplied by 2 for married clients willing to make a gift-splitting election, multiplied by the number of beneficiaries, and get literally hundreds of thousands of dollars into those insurance trusts. And yet not every client does that, because they don't need to get hundreds of thousands of dollars into that trust. They're looking to get only as much in as might be necessary to pay that year's current premium. But if in the future, with a proposal under the Green Book enacted to limit the amount of annual exclusions to a mere $50,000, should we advise our clients to pre-fund their trusts with the maximum amount that they can do so by multiplying 14,000 times 2 times the number of beneficiaries, so that if there is a famine year, meaning a year after the proposal has been enacted, when they can only put $50,000 into a trust of this sort, they'll have that trust pre-funded to make future years' premium payments. Well, the answer, of course, is that we should do so. Now, we've gotten at least one question, which is an important one, which is, what is the likelihood of any of these proposals being enacted? Ira says that he's unsure what the likelihood is. Gideon, who's perhaps a more opinionated individual than Ira is. Gideon, do you have any thoughts on this?
0% probability that there's going to be enactment of any of these provisions. But then again, Dan, there's always some possibility of forced trading. And since the Republicans so badly want the repeal of the estate tax, in fact, there was a bill just introduced last week, another bill. There have been a multitude of bills that call for repeal of the estate tax. Who knows? Maybe they'll agree to have a repeal of the estate tax with a offsetting carryover basis coming into the law. But I really think that given the full agenda that Congress has on its plate this year, and being that it's an election year, it's very unlikely.
Well, I can't say, Gideon, that I would disagree with that assessment, but I would note that back in 2010, none of us thought that, or actually between 2001 and 2010, none of us thought that there would ever be a year in which the estate tax was allowed to be fully repealed, and of course it was. None of us thought that in 2012 the estate tax exemption would be made permanent at $5 million plus. We all thought that $3.5 million was really the upper limit. So I think, to your point, none of us really can ever know what future legislation might be, and therefore I would encourage all of our clients to take advantage of what we've addressed as opportunities while they can.
Absolutely. Just like our clients, many of our clients took advantage of the exemption in 2012 when we were all concerned about the fiscal cliff, and then might have, after January 1 when it was enacted somewhat permanently, people might have had some misgivings that they rush into judgment here. But I think these kinds of structures that we're recommending here can be done without a lot of, if you're funding grants, you still get back all of the assets that you've previously contributed into the trust. You're only giving away the appreciation. All of these really are giving away appreciation, not really giving away the underlying assets. And so, and with your insurance trust recommendation, I think that's important, because otherwise people are not going to be able to continue to fund their insurance premiums without making taxable gifts. I would invite our audience to send us emails if any of you have any questions, and certainly to talk to us about any services we might be able to provide to you or your family members. Our email addresses, I don't know if they were on the first slide, but drubin at mosessinger.com, or grothschild at mosessinger.com, or izlotnick at mosessinger.com. And thank you all very much for your attention today, and we look forward to hearing from you. Thank you.